Well, thank you and good morning. Yes, my name is Blair Barbieri. I am a partner at Hovey Williams. We do patents, trademarks, copyright, anything intellectual property. We've been around since 1929, always there to help. Today we're going to be talking about how to build a brand, and this is really going towards small business owners and people who are starting their own business, how to kind of get that process started. So just to start with, we're going to kind of go over a few different types of intellectual property. There are generally about 4 types of intellectual property. There are trademarks, which is what we're really going to be focusing on today. And trademarks are basically going to be your brand name. They're going to indicate the source of the goods and services so that people know who they're buying their products from. That's going to be the main, well, that's really going to be all we're going to be focusing on today. So there are other types of intellectual property, and that includes copyrights, and those will be different works of authorship. That might be writings, songs, artwork, anything that you create that's original, that is in some sort of medium. We also have patents. Patents are they're going to be your inventions. So it's going to be processes and methods, machines and devices, and you can go ahead and protect those inventions through getting a patent. And that patent will last about 17 years, and at that point, once the 17 to 20 years is over, the patented product, the invention, will be out in the open, and the public domain now has access to it. Our firm specializes in patents, but I do not in particular. I am more of the trademark expert and attorney. And finally, there are also trade secrets. If you have a very valuable secret or valuable information or a valuable invention and you don't want the public to know what that invention is or what that formula is or what that secret is, you can protect that still through intellectual property rights, and that's going to be through your trade secrets. The main thing with trade secrets are you really have to keep that valuable information confidential. So you have to go through specific means to keep that secret. The big one, the famous one, is the Coca-Cola recipe. It is a formula that nobody knows and nobody needs to know because that is their proprietary trade secret information. Customer lists are also considered trade secrets, manufacturing processes, items of that nature. So back to trademarks. What is a trademark? Trademarks help consumers identify particular goods and services. It's a source indicator. So it helps any purchaser, the consuming public, identify and distinguish the source of the goods or services of one party from those of another. So for example, if you see the Starbucks logo, or you go to Starbucks and on the storefront they have the Starbucks logo, you know exactly what you're getting. You know who is providing you with the services, the coffee services that you're getting. You know whose brand the coffee is, Starbucks. They have a reputation, and that reputation is built around their Starbucks logo and brand name, and it really helps identify them from Caribou Coffee or some other coffee provider. Trademarks are valuable assets of your business, so they are going to be valuable both property-wise and goodwill. When you go, once you're so successful in your business and you want to go ahead and sell it off and start your new venture, your intellectual property is going to be a part of that value if you want to sell it off. It's worth money. And the more you protect your trademarks and the more you use your trademarks, the more valuable they become. Not just monetarily, but also with the goodwill. So back to Starbucks. Starbucks has a very famous, well-known reputation. They're known worldwide for their coffee, and people love their coffee because they've acquired this amazing goodwill amongst consumers throughout the world. And that goodwill is incredibly valuable. So there are several different types of trademarks. You have your just general standard word mark, Wall Street Journal, Pepsi, Coca-Cola. Those are just your general standard word marks. You're going to get very broad protection for word marks. It's not going to be connected to a specific font or style or color or particular usage. It's just going to be those words alone, spoken, written, in any manner. You can also trademark design logos. And you can do this with or without the words, the words of your trademark. So for instance, as you can see here, the Microsoft Windows symbol. Everybody knows what that symbol is. It is a well-known trademark. the Apple symbol, and the Nike swoosh. Those are all very well-known designs where you don't even need words with them. You know exactly what you're looking at the second you see those designs. And you can get registrations on those designs. You can also trademark certain letters, like CBS, the AT&T, NBC, ABC. Those are also trademarks, even though they might be initializations or acronyms for something. As long as the letters themselves are well known and what's going to be that source indicator amongst the public, you can still get those trademarked and you can still use those letters as a trademark. Then we get into a little more nuanced trademarks, such as sound. The NBC chimes, those are trademarked. They have a registration on that noise, that particular da-da-da. I probably was a little off. The MGM's lion roar. When you're sitting in a movie and you hear that lion roar, you know exactly who produced the movie. You know what you're getting into, and they have a trademark on that. Recently, a very interesting one is somebody trademarked the smell of their product. When you open that Play-Doh canister and it pops you in the face, that is now a trademarked smell. And the smell is actually described rather, I think it's spot on. It has hints of vanilla and cherry and smoke to it. So that is now a trademarked smell, which is fun and interesting and difficult. It was a difficult path. You can also trademark colors if the color is going to be very specific to your mark. It's very difficult. Cheerios recently tried, and because there's so many other yellow cereal boxes out there, they couldn't get it. Golden Grams was saying, well, we have yellow boxes too, so they weren't able to do it. But color is trademarkable if it is very source specific. So you can also trademark house marks, and that's going to be, if you have several sub-brands and you're really operating as a particular business with the house mark, but you're going to have other sub-brands underneath it, you're going to want to use your house mark with all of those other sub-brands. So you can start collecting a family of marks. So Nabisco, Ritz, back to Microsoft. Microsoft has a whole plethora of sub-brands and sub-products that they use with their house mark. Microsoft Word, Microsoft Excel, Microsoft Office, all of those things are going to be under that house brand Microsoft. You can also trademark taglines and slogans. When you hear "I'm loving it," you automatically think, okay, I should probably go get a cheeseburger from McDonald's. It's all inside. JCPenney's, King of Beers is Budweiser. You can definitely trademark a slogan as long as, once again, that is being used to identify the source of those products. So just do it. Nike has that slogan obviously just under wraps. You can see also on these examples are good examples of also using your house mark with other marks. So the golden arches for McDonald's, the golden arches alone are going to be a trademark, but it's also a trademark combined with the "I'm loving it" underneath it. So you can use your trademarks in several different ways and manners to get the best protection and combine as you so please. You don't just need to have one trademark on something. So now that we've talked about the different types of trademarks, the next question is, how are you going to choose a trademark? As a small business owner or as a startup company, it's going to be really important to choose your brand name. That's going to be what people know you by. It's going to be something you're going to attach your goodwill and your services to for the remainder of your business, hopefully. So when you're starting out, it's really important to decide how you're going to choose a trademark. And there are two main things that we like to look at. The first one, is it likely to cause confusion with another mark? In the world of trademarks, to have exclusive use of your mark is what you're really aiming for. You do not want to use a mark that is similar to somebody else's. You want to make sure that your mark is distinguishing you from other people. And so you don't want to get a mark that might be McDonald's instead of McDonald's. Because it's going to sound just like somebody else's. You really want to separate yourself from the next guy, and you want to make sure that people know you for who you are. So, is it likely to cause confusion with another mark? The main things we look at are going to be the similarities of the mark, And in particular, we're going to look at the sights, the sounds, and the meaning. So do the marks look alike if you're just looking at them side by side? If so, you might want to choose a different mark. Do they sound alike? Do they rhyme? Do they give the same meaning? Do they give the same commercial impression to somebody who's just walking by and sees your mark? Are they automatically going to think that's your mark? Or are they going to think that's somebody else's mark? Also, all of the trademarks are tied to the goods or services that they're offered in connection with. So when you're looking at whether or not your mark is similar to another person's mark, it's really also going to depend on the goods and services that you're providing underneath that mark. For instance, Delta. Delta is an airline. Delta is also a faucet line. You buy a Delta faucet and you realize that Delta faucets are not being provided by the airline company. They are completely separate. They are completely different goods and services. And so even if you're using the same exact mark, if it's going to be completely different products, it's going to be all right, and it's not necessarily going to be confusingly similar. So how do you decide if these other marks are out there that might be confusingly similar to yours? We do a trademark search. You can do that on your own via an internet search. You can look at the U.S. Patent and Trademark Office records at uspto.gov, or you can call us and we'll do a trademark search for you. All of those things they'll get you started on whether or not there might be other marks out there that are going to hinder your ability to use your mark and really claim control of your brand name. If you do a search, sometimes the results are not exactly what you want. You have to be open to maybe adding something very specific to further distinguish your mark so that you're no longer in that confusingly similar range with somebody else's mark. The other main thing that we look at is whether or not the mark merely describes your products or services. We're going to get into this in just a second, but the more descriptive your mark is, the less likely it's going to be protected as a trademark. The main purpose for that is really that people don't want to, the trademark office the trademark law won't allow you to own a trademark that is just, and have complete exclusive monopoly rights over a word that describes something, because other people need to be able to use that to also describe those products. And so in that case, so generic marks, they're not trademarkable, they're not registerable, they are not protectable trademarks. So if I started a company that was selling tables, I couldn't name my company Tables. That wouldn't be a protectable trademark. Descriptive marks, they can be trademarkable if you've been using them for long enough. So if I were to say I'm still selling tables, but my company is now going to be called the Table Manufacturing Company. Maybe if I'd been using that for 5-10 years and I've really acquired some goodwill and people know me by that mark and I've put a lot of money into it and I have a design logo that goes around it and near it, then I might be able to trademark that particular mark, even though it is slightly descriptive. So long-term use and acquired recognition is going to be required for protecting a descriptive trademark. In sum, the less descriptive, the stronger the protection, and the more descriptive, the weaker the protection. Another thing just to keep in mind is that a mark that merely conveys your contact information is not going to be considered a trademark outright. If you buy a domain name and you say, well, I've registered this domain name and I use it in my email address. If you're not using it outwardly and actually marketing or selling your goods or services under that mark, the fact that it merely conveys some information is not going to really move it up into that trademarkable world. So when it comes to the strength of trademarks, we have a spectrum that we look at. And we touched on that briefly in the last slide, but this is really important. So generic marks, once again, they are not registerable. The generic mark would be an actual name of the goods or services you're providing. Example, computer, driving, engineer. Those aren't trademarks, those are things. So they are not protectable. Next up in this spectrum is going to be your descriptive marks. And your descriptive marks, they merely describe a feature, characteristic, or function of the goods or services. And like I said, They can be registrable and trademarkable, but it's really going to depend on how long you've used it, the kind of goodwill you've acquired that's attached to that mark, really making it so it's a source indicator rather than just a descriptor. Some examples would be Truck Center or Water Park Association. If you just opened up a water park association and you decided that that was going to be your name and you went to the trademark office directly, you would likely get a refusal for registration that says, well, that's just merely descriptive. You need to come up with a little bit more, whether it be a strong design or another word element that comes before or after the water park association. Something else that sort of distinguishes it more as a trademark rather than this is what we are. The next type of mark on the spectrum here is the suggestive mark, and as the name suggests, it suggests a characteristic of a good or service without actually describing it. It requires the purchaser and the consuming public to put together something in their mind where they see the mark and then they don't know just right away what it is you're offering. They have to think about it a little. And they have to put things together and be like, oh, okay, this suggests that might actually be something, that they might be selling this instead. For example, copper tone. If you just hear the words copper tone, well, now we know it's sunblock or suntan lotion. But when copper tone started, it was a very suggestive mark. They're kind of talking about toning your skin and the color, and it's playful, but it's still suggestive of what it is that they're offering and what the end goal is of their products. On the next level is the arbitrary mark. And as we move up this spectrum, the more and more protection and the stronger your mark is going to be. So arbitrary marks are incredibly strong. They're words with separate meaning, but nothing to do with the associated product or service. So Apple is a great example. You could, if you were selling apples, your business couldn't necessarily be called Apple, but if you're selling computers, apples have nothing to do with computers, and so it's completely arbitrary that they're using this mark. And it's a really strong mark. Camel is the same way. We all know camel's an animal, but when it comes to cigarettes, that's completely arbitrary. And fanciful marks are your most protectable, your strongest marks. They're made up words. We all have it in us. We can make words up, and it's fun. And when you do that, you have very strong protection in your mark. They have no other meaning other than being a trademark. So Verizon is a good example of a fanciful mark, Kodak, Tylenol. Some marks start very fanciful, and because they're so fanciful, they become what it is that they're selling, such as Kleenex. Kleenex has had some issues with this. They've now become generic because when you think of facial tissue, you think of Kleenex. Not necessarily the brand, but the item. So that's something to look out for. But that shouldn't make you shy away from using fanciful marks. So once you've chosen your trademark, now you get to start using it. Once you start using your mark, you're going to want to put that little TM symbol that everyone's seen before and thought, what is that doing there? It's a TM symbol, and you put it just in superscript at the end of your mark, and you want to use that whenever possible. What that does is that provides notice to everybody else that you are using your mark as a trademark. Once you get rolling and once you start getting protection on your marks and registrations start just rolling through, then you're going to change that TM symbol to a registration symbol. And that's the R with the circle. And you should always use the registration symbol once you have a registered trademark. It's important to keep those two separate. You use the TM when you don't have a registration, but you're still using your mark. And then if you get your trademark registered with the U.S. Patent and Trademark Office, you're going to switch that TM to an R with the circle, the registration symbol. And it's important because, once again, this provides notice to all the public and all of the world to know that you're using your mark and it's registered, and they don't have the right to use it. Because once it's registered, you get to exclude everybody else from using your mark with the same goods and services, that is. So it removes any sort of defense of innocent infringement. If somebody says, well, I didn't know you were using that mark. Well, yes, you did. There was a registration symbol on there. So it removes that entire defense. So speaking of registration, once we start using marks, we would always suggest going for a registration to protect it and really get it pinned down and protected. First step is whether or not your mark is available for registration or use. We hit on this earlier, but searches are definitely the best way to do that. They'll help determine whether the mark is available for both registration and use. You can do different levels of searches. So if you wanted to go to a search engine and type in your brand name and see what else was out there that might be using your mark, or what else your mark might be out there in the internet world, in the World Wide Web, what it's doing out there, you could do that. And that would help it go towards whether or not you could use the mark. Or you would go to the US Patent and Trademark Office and their website and do a search there. And you could look at their different records, and you would look at whether or not there were existing trademark registrations, or if there were pending applications, anything that might come up that's similar to your mark. The search on the USPTO's website is not the greatest. Of course, I would suggest you come to us and we'll do a search for you. We do 2 different levels of searches, and most law firms will. The first one is going to be just looking at the federal records. Again, this is going to be looking at the records that are actually at the US Patent and Trademark Office. All of those pending registrations, all of the all of the active registrations and all of the pending applications. We'll look through that. And then we could also look through state trademark records and look to see if anybody in your state or anyone near you might be using a similar mark. You can also do a domain name search, and you could go to GoDaddy and do this on the internet, or again, we could do that for you. Then you have your common law searches. So we offer and again, most firms do, we offer a very comprehensive search, and that's going to look at everything we possibly can find. It's going to look at the federal records, it's going to look at state records, it's going to look at domain names that are registered, it's going to look at business name directories, phone books, internet usages, social media. It's going to look at anything and everything we can find. And at that point, if you go through that search and you realize there's very minimal risk, and we think that our mark is actually, one of a kind here, then you can move forward and know with confidence that you can use your mark. And if you've just done a search of the federal records, then you might be able to register it. So now that you've done your search and you've started using your mark with the TM symbol, what happens now? Protection. We want to make sure that we protect the marks that we use. So even if you don't get a registration, once you start using that mark in commerce, and when I say in commerce, it's kind of a term of art, use in commerce, it means that you're using your mark in connection with the products or services you're selling. You're actually putting it out there. So if you're selling products, it's going to be you're using the mark with the products that you're selling, whether it be as a store name, whether it be on product packaging, whether it be an online listing, you're actually using your mark with these products that you've sold now. For services, if you're offering some type of service, it's going to be that you're using the mark in your marketing and advertising. So if it's your company name, your brand name, your bread and butter there, that's going to be using your mark in commerce. It's once you start actually marketing and advertising those services and start providing them to the public. So once you do start using your mark, you actually acquire common law trademark rights. And they're quite valuable. They're not the most valuable, but they are valuable. The issue is they freeze in the geographic region that you're using your mark. So if you're using your mark in Liberty and nowhere else, then you do acquire common law trademark rights, but those trademark rights stop in Liberty and the surrounding areas. They might reach to Kansas City, throughout the Kansas City metro area, but they're really not going to, you wouldn't be able to enforce your trademark rights in LA or in New York or in Florida. You wouldn't be able to do that. They're really frozen in the space that you're using that mark. So if you're interested in really protecting your trademark within the state that you're in, you can also go to the Secretary of State's office and you can file for a trademark application and register your trademark with the Secretary of State. They don't do any searches, so it's kind of like you have to, you just have to apply. And really, they have different standards that you need to meet and different things that you need to submit with the filing. So as long as you hit all of those buttons, then you're going to go ahead and get your registration. And it provides constructive notice within your state that you are using that mark and that you own that mark. It will also provide evidence of local ownership of the trademark. If you ever get in a tussle with somebody over trademark rights, you can use that as evidence to say, I've been using this mark in the state and here's my proof of evidence. It does give you availability to state court jurisdiction. So if you come into a trademark infringement issue, you can go ahead and use that state trademark registration to get in both the state local court jurisdiction. There's a little parentheses at the end here that they're not as valuable as a federal registration. The federal registration is what we always recommend. Federal protection and registrations give you the maximum benefits for your trademarks and your trademark rights. This is where you're going to file an application for your mark with the U.S. Patent and Trademark Office. Doing this provides a plethora of benefits. First, other people can find it when they're searching. So let's say somebody else is trying to figure out how to choose a trademark, and they can go and actually find your mark quite easily now. If they go to uspto.gov website, they can look and see that you're using the mark already, which that might squash an infringement issue just right at the get-go. On top of that, it gives you rights to use the mark nationwide. So whereas those common law trademark rights are really stuck to the area you're using it in, if you have a federal registration, you can exclude others nationwide. And so that extends throughout the nation. There is a small exception. You might not be able to enforce your rights or exclude others from using a mark if they've been using it before you within a specific geographic location. So let's say somebody was using a mark in Liberty and they had common law rights there and they've been using it since 1975. You get a federal registration, you wouldn't know that they're using their mark if you hadn't actually been in their store or bought their goods, and you get a registration. Well, you might not be able to exclude them from using their mark in Liberty because they were using it first, and they do get priority there in their particular geographic region of use. After you've registered your mark, and it's been registered for 5 years, you also get a wonderful benefit. The registration itself becomes incontestable. Not only does that sound amazing, it is amazing. So the registration, at any point during the registration's life, and during the first 5 years in particular, if somebody else comes along and wants to challenge your registration or invalidate your registration or attack it in some way or another, they're free to do so. But after 5 years, several of those grounds that would otherwise be available are going to be removed. They can't attack your mark for being descriptive. They can really attack it based on fraud. If they think that you've committed fraud somehow or another, trying to obtain the registration, or a very limited number of other grounds. So that incontestability status is really a strong thing to hold and have with your trademark registration. Also, your registration is going to provide constructive notice of your ownership nationwide, which is something that's very good if you get into an infringement battle. The benefits of federal protection keep on going. So it's going to provide evidence of your ownership of a trademark. So if you ever need to defend your trademark rights, that registration is going to give you a presumption that you own and validly own that mark. So you don't have to go through the arguments of, well, this is how I own it, this is why I own it. That registration itself will be evidence of ownership. You can invoke the jurisdiction of federal courts. The Trademark Act is the Lanham Act and is federal law. And so if you have a federal registration, it really gets you right in the doors. If you need to, hopefully it never happens, but if you need to go all the way to litigation, that will be helpful to be able to get access to the federal courts without having a fight or a battle about it. Registration can also help you get your registration and expand your trademark rights expanded into foreign countries. I know for small businesses and startups, that's long trademark rights beyond the US. Filing a foreign application is in and of itself a whole other presentation, but we're always here to help should that need arise. Also, if you have a registration, especially nowadays, it's becoming increasingly important to have a registration for people who are selling on Amazon and different online marketplaces, third-party online marketplaces. So a lot of, and I'm going to take Amazon for instance, because we're actually one of 11 selected firms in the US that we are part of the Amazon IP Accelerator program. And so we help Amazon sellers get early enrollment into the brand registry so that they can reap the benefits from the brand registry without having to wait. Because Amazon will allow you, in several of these online marketplaces, if you have a trademark registration, they'll allow you to enroll in special programs, and you'll get different perks from these programs. You might get marketing analysis perks, sales and cost analysis perks, different things that they'll offer you, A+ content, things like that. They'll also oftentimes offer you enforcement perks. So if you have your brand and your trademark registered with this particular service, and you see somebody else is using your mark on another listing, being a part of the brand registry will then allow you to easily go in and have those enforcement perks right at your fingertips, rather than go through all of the different infringement reports or other reports that you might otherwise need to go through. So we're starting to see this more and more, where these online marketplaces and these forums, if you have a registration, you're going to be able to really enforce your rights so much easier, and then you'll also be able to usually get some other perks for selling purposes. And that kind of also goes to the next point, where it increases the ability to report infringements that are posted on different social media accounts. I don't know if I deal with it often. So Facebook, Instagram, Twitter, other people just kind of ripping off other people's trademarks or products. And the easiest way to do it is go in and fill out an infringement report form with the platform itself. And they have a space where you can put your trademark registration number. If you don't have the registration number, it's not that you can't get the content and the infringing content removed. That it's just that much more difficult, and you have to go back and forth, and sometimes they say, no, we don't really know that you own this. And once again, that's when that registration that is evidence of your ownership of the mark comes in handy. That's just an example. So once you've thought about all of these different ways to protect your mark, and you decide, oh my, I think federal protection is the way to go, you want to go ahead and get that procedure started. So first off, we've kind of spoken about it a couple times. It's really important. Trademarks can't be confusingly similar to other marks. So the procedure starts with filing an application with the U.S. Patent and Trademark Office, and that application will then be examined. The main thing they look at is what we talked about kind of right at the get-go. Are there other confusingly similar marks that might conflict with your marks? Meaning, do they sound similar? Do they look similar? Do they mean the same thing? And are they offered with similar goods or services, or overlapping goods and services? When you file your application, the U.S. Patent and Trademark Office, they're only going to look at their records. They're not going to look at social media accounts. They're not going to look at domain name registrations. They're not going to look at business name directories. That would be a chore. That would be very difficult. So once you do realize, or once we've gone through the search and we think that we are at minimal risk and we can go ahead and file that application with confidence, you can file your application on 2 different filing bases. Well, you can file them on several, but these are the 2 main ones for U.S. applications. You can file it based on your actual use of the mark, and this means that after you've used the mark in interstate commerce, you can go ahead and file that application based on your use. This goes back to what we talked about just a few minutes ago. That means that you've actually sold products in the U.S. is going to be your actual use in interstate commerce. You have to have sold the products or marketed your goods and services that have been provided in the U.S. in connection with your mark. So that's going to be a use-based application. If you haven't used your mark yet, but you're starting to get ready and you're getting all of your inventory in, you're getting all of your packaging in, you're getting all of your store signs in, and you want to make sure that you can save your mark and you kind of reserve your spot in line for that mark, you can still file an application even if you haven't used the mark yet. You can file it based on your intent to use the mark. And these applications can be filed with the USPTO, and what it does is it just reserves the mark at the USPTO before it's been used. And then once you do actually use it, we would submit a form with the USPTO that shows that you've used it, and then you can get a registration issued from there. Now that we have a registration issued, how long does that federal registration last? It can last forever. As long as these items are maintained, your trademark can potentially last forever. Your registration can. The big thing is that you have to continue using your mark. There's a presumption in the United States that if you don't use your mark for a span of 3 years, you have abandoned your trademark and you no longer have trademark rights, and that trademark is now back in the open, ready for anybody else to grab. So continuing to use your mark is very important. If you continue to use your mark and your mark hasn't become generic, like Kleenex or Velcro is on the good fight to keep their mark from genericide, Q-tips, Google just had a big thing. If you notice, I've been saying internet search engines, you can go to your search engine. Google has been fighting the good fight to keep its mark from becoming generic. Right now they're doing a decent job, so that's good. So as long as your mark doesn't become generic and you've continued to use your mark, and then for the registration purposes, between the 5th and 6th year after you've registered your mark, you're going to need to maintain it. And all that means is that you need to file a submission with the trademark office that says, I'm still using the mark, and I declare I'm still using the mark, and I've been using the mark, and here's some proof of evidence of my use of the mark. So that's the maintenance that happens between the 5th and 6th year. That's the only time you'll need to do that particular maintenance. But then, every 10 years from the registration date, you'll also have a renewal that comes due, and it's the same type of submission. You just need to submit a statement that says, I declare I'm using this still, and of course, pay the government filing fee. Also, it's important that once you have your registration, one of the benefits of having a registration is that you can exclude others from using it, but you can also permit others to use it based on how you want them to use it. So you can license your mark. You can license your rights in the mark to allow some other party to use it for whatever purpose they need to. And you can collect royalties, you can collect money from that. The important thing is that you as the trademark owner always have control of the quality that your mark is used, in which your mark is used, and also with the goods and services that it's used with. So we want to stray from what we call naked licensing, which is really just letting people use your mark without your ability to control how it's being used. So as long as we follow those items and don't let other people just nilly-willy infringe on your mark, then you can have that registration and that federal protection in perpetuity. So speaking of infringement, infringement is the unauthorized use of another's trademark or any confusingly similar brand. So once again, we get back into that confusingly similar zone. You don't want to, if someone else is using a mark that is confusingly similar to yours, it sounds like yours, it looks like yours, it has the same meaning as yours, they're offering the same goods and services under these confusingly similar marks, that's still considered infringement, even if it's not your exact mark. The first step, seek legal advice. There's an exclamation point after that because it's very important. Sometimes it is great to conduct business and resolve these issues business to business. I would still say go ahead and seek legal advice first before reaching out to the business. The risk is that what if they were actually using the mark first? Then you might have just given yourself up for infringing their mark. So it's really important to get all of the facts that we need, because the infringement analysis, it looks at 13 to 15 different factors, and it's very important that all of those things are considered before just going after somebody for infringement. However, once we've sought legal advice and we know that somebody's infringing our mark and we need to get it to stop, there are several different options that you can take, and the typical options are going to be your cease and desist letter. That's the famous one, and that's going to open up a dialogue with the infringer to say, we want you to discontinue using this mark, you need to stop infringing, and you need to represent in writing that you're going to do so. Depending on the level of infringement, it might also include a demand for monetary award of some sort of monetary payment to get back what you might have lost from their infringement. Another way to go about this is reporting infringement through a third-party website, kind of like we talked about with Facebook or Instagram or Amazon, or we'd be here forever if I went through all of them. But they usually have a pretty good IP reporting policy and procedure in place. You can always call an attorney to ask for help with that, because we deal with this often. And it's all a little different. Every third-party website has their own procedure and manner in which they do it, but typically there will be some sort of mechanism where you can report infringing content, because they want to stay out of it, is really the main thing. They don't want to be a party to an infringement lawsuit. They want to give you the mechanism to go ahead and go take care of that. The next one is a UDRP complaint. This is actually more of a domain name dispute issue. If you have a trademark that's registered and somebody uses your trademark and files or registers a domain name, and they start using that domain name and the website that it's operated through in an illegitimate fashion, whether it be selling your products, but selling counterfeit products, fraudulent products, or worse, you can go ahead and stop that use if it's illegitimate by filing a UDRP complaint, and that's going to be filed with the World Intellectual Property Organization. And the main goal is it's a very streamlined procedure, and the main goal is to get that domain transferred to you or just removed entirely. And we never want to go there, but it happens. You can file a lawsuit. If you try all these different methods and you're really dealing with a whack-a-mole kind of a situation, or somebody just refuses to stop infringing, you can file a lawsuit. And if you have a federal registration, you're going to be in the best position to file this lawsuit. You're going to have the most available remedies for you. And some available remedies might be an injunction, which means that the court orders the infringing party to stop infringing. They can't use your mark anymore. They can't sell their goods under the mark anymore. They have to destroy all their current inventory they have. They have to give you an accounting, all of these things. You can also seek money damages. Oftentimes, if you're the prevailing party and it is an exceptional case, which is kind of a high standard, but you can sometimes get your attorney's fees back. And like I said, you can also get a remedy where they have to destroy all of the infringing inventory or product. And I think we're just about out of time, and I sort of hit on the last slide already, so I'll just put it up there, but really that's dealing with domain names. And one thing to keep in mind with domain name disputes is that sometimes your biggest hurdle is going to be that all of this has to be in bad faith. A trademark infringement lawsuit and bringing a trademark infringement claim doesn't require that the other party has intentionally infringed. Infringement alone is enough to infringe. Whereas if you get into a domain name dispute, that bad faith intent is really going to have to come in and play a part in it. And that is all I have today. I think we ran just at the 45-minute line, so I'll go ahead and end there. Thank you so much for having me. I appreciated it.